This is English shorthand dictation number 365 and the dictation speed is 120 words per minute. Ready? Start. We have heard the learned senior counsel appearing for the appellant and the learned additional solicitor general for the respondents. We have perused the pleadings, documents, and judgments. The present appeal is at the behest of the brother in law of the détenu who is challenging the validity of the detention order and aggrieved at the refusal of the High Court of Calcutta to set aside the order of detention passed by the respondents. On receiving information pertaining to a consignment containing gold and foreign currencies escaping the watchful eyes of the Customs Department, four persons were apprehended. On eliciting further information from them, a search was conducted, yielding huge quantity of gold, along with the recovery of foreign currencies of various denominations. As a consequence, the detainee was arrested, followed by a detention order passed by the detaining authority in exercise of the powers conferred under Section 3 of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. Prior to the said order, he had obtained an order of bail. The detention order was passed against the detainee on 05/09/2023, after which he was subsequently detained on 19/09/2023 from his home in the presence of his family members. Following the heels of the said order, the respondents made an endeavor to serve the grounds of detention along with the relevant documents on 20/09/2023 with due translation in the Bengali language. The detainee, who was in a correctional home, firmly refused to receive them despite persuasive attempts made by the respondents. A panchnama was prepared, and before its due execution, another abortive attempt was made to make him receive the grounds of detention along with the relevant documents. The detainee reiterated his earlier stand. However, a facility was extended to him to read the documents in its entirety. The Panchnama was signed not only by two independent witnesses but the detainee as well. Interestingly, the detainee, after signing the Panchnama in the English language, has proceeded further to write, I have refused to receive any document, leading to the obvious inference that his so called ignorance of English was only an afterthought. Two more attempts were made by the respondents to serve the documents along with the grounds of detention. After refusing to receive the same on 03/10/2023, it was finally received by him on 10/10/2023. Interestingly, the detainee, through the appellant, filed the writ petition on 03/10/2023 inter alia, contending that the respondents have not served the grounds of detention. The division bench of the High Court of Calcutta dismissed the writ petition inter alia, holding that it was the detainee himself who had refused to receive the grounds of detention, a fact clearly indicated and proved through the Panchnama. Learned senior counsel appearing for the appellant submitted that it is incorrect to state that the detainee has refused to receive the grounds of detention. In any case, the detainee has not been informed or communicated regarding his right to make a representation against the detention order. Both functions are mutually reinforcing as mandatory under Article 22(5) of the Constitution of India 1950. Not all the relevant materials have been served on the detainee, such as the telephonic conversation between the detainee and others, the grounds of detention, could have been served on the family members of the detainee even on the first occasion. There ought to have been an affidavit on the refusal of the detainee pertaining to the grounds of detention by the official concerned on the question of the contents having been read over to him and being read by him, an order of detention being an exception. If two views are possible, the one in favor of the detainee should find favor with the court. Article 22(5) of the Constitution of India can broadly be divided into two parts. Of these two parts, there lies an underlying duty and obligation on the part of the authorities in not only serving the grounds of detention after due service of the detention order and communication of the grounds of detention along with the documents relied upon in the language which he understands, but also for the purpose of affording him the earliest opportunity of making a representation questioning the detention order. Therefore, the first part involves the bounden duty of the authorities in serving the grounds of detention containing such grounds which weighed in the minds of the detaining authority in passing the detention order. In doing so, adequate care has to be taken in communicating the grounds of detention and serving the relevant documents in the language understandable to the detainee. The second part is with respect to his right of making the representation. For exercising such a right, a detainee has to necessarily have adequate knowledge of the very basis of detention order. There is a subtle difference between the background facts leading to detention order and the grounds of detention. While the background facts are not required in detail, the grounds of detention which determine the detention order ought to be found in the grounds supplied to the detainee. In other words, the knowledge of the detainee is to the subjective satisfaction of a detaining authority discernible from the grounds supplied to him. It is only thereafter that a detainee could be in a better position to take a decision as to whether he should challenge the detention order in the manner known to law. This includes his decision to make a representation to various authorities, including the detaining officer. Therefore, an effective knowledge as being a detainee is of utmost importance. On the second aspect, a detainee has to be informed that he has a right to make a representation. Such a communication of his right can either be oral or in writing. This right assumes importance as a detainee in a given case may well be a literate, semi literate, or illiterate person. Therefore, it becomes a cardinal duty on the part of the authority that serves the grounds of detention to inform a detainee of his right to make a representation. While the aforesaid two rights and duties form two separate parts of Article 22(5) of the Constitution of India, they do overlap despite being mutually reinforcing. Though they travel on different channels, their waters merge at the destination. This is for the due compliance of Article 22(5). The entire objective is to extend knowledge to the detainee, leading to a representation on his decision to question the detention order. Such a right is an inalienable right under scheme of the Constitution of India available to the detainee, corresponding to the duty of the serving authority. In a case where a detainee is not in a position to understand the language, a mere verbal explanation would not suffice. Similarly, where a detainee consciously declines to receive the grounds of detention, he has to be informed about his right to make a representation.